Yeah.
Is this my the judge and the attorney that's on the phone right now?
Yes.
Yes, that's Miss Erickson. Is your attorney? Do you need a moment do you need a moment, Deb?
No, Judge, I think that we all understand what we're hoping to have done today.
Yes,
Sure.
yes, yes.
The agreement on this one, well, I don't know what the original agreement on sentencing was, Mr. Davis, but I will tell you this, that I received your correspondence from prison there and indicated that you wanted to get this sentencing done, so there wasn't a warrant sitting out on you that might keep you from accessing some of your programs. All of the parties agreed to hold this. And I believe they're all recommending to me that I give you your normal sentence under this case, but run it concurrently with your federal time, so it doesn't give you any extra time. It won't be giving you probation afterward, but you will have to serve basically what's called post-release supervision, which is our version of parole. However, that might all run and expire before. How much time you got there with the feds left?
On this 84-month sentence, I got exactly like 8 months left.
All right. Well, chances are when you get out that you're going to have to do a little stint of parole. But if you're doing federal parole, they'll just courtesy supervise you, I'm sure. So I don't think you'll be looking at anything extra, although, you know, that's kind of beyond my expertise. So don't take that as a guarantee, because I don't know how the feds handle it exactly.
Okay.
All right. Anybody need to talk about anything before I call the case?
Yeah,
No,
Judge,
sir.
I need to talk to Adam for just a sec.
Sure.
I don't need a meeting. I'm gonna walk across the room here.
Yep. Amanda, so you know our 11 o'clock. Adam is not going to be ready. So I'll be in touch when we're off the hearing here, but I think there's a good chance that we're not going to need a record for 11 o'clock.
Okay. Good to know. And we're still having the demo at 1?
And I haven't been notified otherwise yet, so
Okay.
I'm guessing yes. And we'll make sure from Deb that that is in fact the case. It appears that she has left Adam alone, but has not returned to
No,
her
I
seat.
see. I think I see a shoulder in the far left of the.
Oh,
Yep.
there we go. Oh, okay.
Mr. Davis,
Yes, ma'am.
you said you're done in 8 months. Are you done with your entire sentence or are you going to a halfway house?
Halfway house.
And you go to a halfway house in 8 months?
Yes, ma'am.
Sorry, Judge, we had to figure out how to work this sentence so he could actually go to the halfway house if the court agrees with what we're trying to do.
So the time that's running concurrent with this sentence is the 17 months, correct?
That,
Um,
I think your um, presumptive time is 15, 16, or 17. I think what the lawyers are trying to work out here is to recommend to me something that's not going to, something that's going to expire by the time your federal sentence expires, so you're not doing any more time.
Yeah,
Oh,
hey,
okay.
Judge, can you hear me, Judge? There's a bit of an
Yep.
audio. Okay.
I can.
I think we've agreed, just because it seems too messy to try and mess around with jail credit and figuring out various things. The state's going to propose a modified sentence of 7 months. So as to, I mean, taking Mr. Davis's word that he's getting out in 8, this will expire then a month in advance of that and shouldn't complicate the federal release and supervision that would come with it.
Okay. Good with that.
And Judge, I did not file a departure motion because honestly, I didn't realize this situation was going to come up. So I can orally give some reasons.
Yep, that sounds good to me. All right. Okay, then it sounds like we're ready to go, and I'm going to call case number 2013-CR756, captioned State of Kansas versus Brandon Davis, with the parties announce their appearance.
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Sokoloff.
May it please the court, Mr. Davis appears via Zoom with counsel Deborah Erickson, and I'm appearing from a different location.
All right. We are here set down for a sentencing. I'll tell you that the parties were in court back in November of 2015. At that time, I believe that the defendant had pled guilty to eluding a police officer. The court had acquired and accepted that, set it for sentencing. But in the meantime, the defendant was taken into federal custody where he's remained since. A few months back, I got correspondence from the defendant asking me to conduct his sentencing virtually so that this warrant would be removed and he could move into rehabilitative programs in federal custody. I appointed Ms. Erickson because she has some experience with hooking us up with out-of-state federal custody locations. And Mr. Sokoloff was the prosecutor. We talked and all parties agreed that we could go forward with this. I let the probation office know so that they could update their PSI, and they have done so. And I've reviewed that PSI. The critical findings are as follows: that the sole count of conviction in this case is one of eluding a police officer. That is a severity level 9 person felony. The defendant's criminal history score was found to be that of A as in Adam. That would leave him with a presumption of prison and a presumed underlying range of 15, 16, or 17 months. There was special rule number 9, which was that he was on felony probation at the time of this offense. So that would leave him with that presumption of sentence. If he has to do that time, he's eligible for up to 20% good time credit and subject to 12 months of post-release supervision. If he were granted probation today, it would be for a period of 12 months to community corrections. I would ask you first, Mr. Sokoloff, do you have an opportunity to review this amended PSI? Any additions, corrections, or challenges to those findings?
The state did receive and review the PSI, and I have no challenge or amendment.
All right, Ms. Erickson, same question.
Judge, I've reviewed the PSI. I don't have any challenges or amendments. It looks like one of those person felonies is a result of a conversion from person misdemeanors, and the other two are older person felonies.
Right. And my understanding is, although it's mandatorily consecutive, that felony probation case in 11 DV 633 out of Johnson County, that sentence is already expired. Am I correct in that, Ms. Erickson?
Judge, I don't know if that has expired yet or not. I would assume that it has if they've not filed a violation.
Yeah, I did prison time for that.
Yeah, he was sentenced on December 19th of 2011.
Mhm.
So it would have had to expire one way or another by now, even with numerous
I would think
extensions
so.
if that occurred. So I'm not worried about that. All right. Ms. Erickson, there's not a motion for departure, but that's because the parties believed starting this hearing that we were going to be recommending within the sentencing guidelines. However, my understanding is, given what Mr. Davis told us today, that his federal case expires in 8 months, that there may be a request for a departure. So I will leave that to you.
Judge, I would request that the court sentence Mr. Davis to a term of 7 months in prison, and that the court run that sentence concurrent with the federal sentence that he's presently serving. That case number, Judge, is listed as on number 1 of the criminal history sheet that's been prepared by the PSI writers. The reasons that I would request that you do that, Judge, is I believe that it's going to be an agreement of the parties that the court do that. Further, Mr. Davis did not require the state to have a trial in this matter, saving the state time and money and saving witnesses from having to testify. Further, Judge, sentencing him to a longer term may prevent him from participating in the halfway house program that is set up for him through his federal case. That program, Judge, obviously has a lot of elements to it that would assist him in rehabilitation and helping him to work out in the community again. They have many programs. They have some housing assistance. They have some counseling, employment assistance, many programs that would drug and alcohol assistance. I'd also state, Judge, that the fact that he has served a lengthy federal sentence would make him more amenable to the programs of the halfway house that the federal programs can offer him. So I would request for those reasons, Judge, that the court sentence him to the 7-month underlying sentence and run it concurrent with his federal case.
Mr. Sokoloff?
That's the agreement of the parties, Your Honor. And I mean, Mr. Davis is due to come back into our or someone's community in the not too distant future. We could delay that by another half a year or so, but it would be to the effect of him missing out on the rehabilitative services that I think we all want him to get before he reenters the community. And certainly we don't want to be ultimately an impediment to his successful reintegration. And I think that's what we would be asking for if we asked you to add another 8 or 10 months on, for no good reason. The comments of defense are well received. He certainly has served a lengthy sentence, and a few more months we don't believe is in anyone's best interest. So we join, I guess, in the oral departure motion from defense.
All right. Mr. Davis, now's your opportunity to tell me anything you want me to know in mitigation of your sentence today.
No, sir.
All right. Well, I'm going to follow the agreement that I've heard today. I think it is a just outcome in this case, and particularly the defendant having served a long federal sentence here at the end of that. And I think it is a break, but it's a break that he's earned. And well, to the point that I think having served this sentence is sufficient. So I am going to sentence him to a period of 7 months in the Department of Corrections. That will be ordered to run concurrently with his present federal sentence, which is case number 13CR756. That's how it's listed in the pre-sentence investigation. Obviously, if the court or if the parties find that that's incorrect, I'm ordering it to run concurrently with the federal sentence that he is now serving. He'll be given credit for jail time and is eligible for 20% good time credit. He is subject to 12 months of post-release supervision. I frankly don't have any idea how he will get signed up on that. Given that he's in federal custody out of state, I don't know if his plan is to come back here or how our parole post-release authorities are going to be notified that he needs to. So I don't really have any advice as to how to get signed up on that. Given that this
Judge,
case is, go ahead, Ms. Harrison.
Mr. Davis, his mother and a friend of his, along with Mr. Davis, they have my email address and my phone number. If he gets a hold of me upon release to the halfway house, I can try to help him make contact with the probation department or parole office. I'm sorry, parole office, so that he can get that set up.
All right. Okay. Mr. Davis, tell me this. When you get released from custody, do you have expectation for gainful employment?
Yes, sir. I haven't wasted any time frivolously since I've been incarcerated, and right now at this moment, I'm working on my fourth and final certificate to be a certified production technician through a program that they have here called MSSC. And I also, 2010, when I was on the streets, I went to Vatterrock College, so I have a heating and cooling certification as well. And
so tell me this: do you know, if you know, do you have like a large amount of restitution costs and fees and stuff from your federal case?
I have none.
Okay, good. All right. Well, then, if you think you're going to be able to be gainfully employed, I am going to do a couple of things here. I'm going to assess the court costs. It's $195. I'll give you, and look, if you're going to be on post-release for 12 months when you get out or anything, if you can pay, you think you could pay $50 a month towards that? It would take you about 4 months to pay it off. Think you could do that?
Yes, sir.
All right. There's no supervision fee because he's not being granted probation. Ms. Erickson, do you have any idea what your attorney's fees are going to be?
Maybe around $400, Judge.
All right. Well, I'm going to assess half of that versus the defendant, so that'd be another $200. So if you pay towards that at $50 a month, it's going to be about $400 total. You should be able to have that paid off in 8 months. You think that's something you can do?
Yes, sir.
All right. That'll be the court's order that the attorney fees in the amount of $200. I'll waive the bid's application fee because I don't think he ever applied to it. And the court costs. There is no supervision fee. He's already in the KBI database, so there's no DNA fee. That's going to be his own cost, only costs and fees. All right. Mr. Davis, you have 14 days from today to appeal anything you don't like about your sentence. You may also be able to seek expungement after a period of time following successful completion of supervision. As a convicted felon, it's prohibited for you to own or possess a firearm. Certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. you understand all that?
Yes, sir.
All right. Mr. Sokoloff, anything I failed to cover today?
No, Your Honor, I believe that covers everything. Thank you.
Ms. Erickson?
Nothing else, Judge.
All right, then we will be adjourned. Mr. Davis, good luck to you.
I got one question.
Sure,
Um,
we are adjourned, but go ahead.
no, I was just gonna ask, would I be able to have my family recover the property that was taken from me when I was arrested, or is it gone, or what?
I wouldn't have an idea right now. Mr. Sokoloff, at this point, you would normally, I think, file a motion to have it destroyed or anything. What, can you advise me what the protocol on that is now?
You know, I am unaware now, since 8 years have passed since the arrest, whether or not the police department would have gotten rid of that by policy, but I don't think that they necessarily do, because I personally helped them get rid of evidence from the 80s that they've been holding on to for a long time. So I have no problem releasing any and all property that was taken, you know, legal property, obviously taken from Mr. Davis to his family or whomever. I would just need the specific names from Miss Erickson to whom the property would be released, but I'm happy to do that if she provides me a name.
All right. Have your family contact the police department if they will check and see if it's still there. And if so, they will ask permission from the DA's office to release it to your family members. And they're telling me they would be glad to do that, okay?
Yes, sir.
So have them call the police department, the Kansas City, Kansas Police Department, tell them what they're looking for and what the case was. What property is it?
Well, I mean, it's really nothing for real. It's just they took my cell phone, but it got a lot of baby pictures of my kids that I had wanted.
Sure. Yeah. Well, you know, I don't know. You're now talking about a cell phone that's at least 10 years old. I don't know if it would still have the power and have kept all those files. It's possible, but certainly they can call the police department, see if that still exists, and if it is, we'll get it out to them. Okay.
All right, I appreciate it.
You bet.
And
All right.
Mr. Davis, if they need to contact me to give them that information, just have them give me a call. I've talked to your family even this morning.
Okay, so Miss Erickson, so are you gonna fax that judgment of this case to that fax number I gave you?
I can email it or fax it to the prison where you're currently located.
Okay, I appreciate it.
Okay.
All righty.